Hi class, this is exam 2 review slides and exam 2 will cover chapters 5, 6, 7, and 8. Chapter 5 deals with diversity, equity, and justice for all. What is the Title VII of the Civil Rights Act of 1964? Title VII makes it unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of the individual's race, sex, religion, national origin. The ultimate question in every Title VII case is whether the plaintiff has proved that the defendant intentionally discriminated against her or him because of a protected characteristic. The federal agency that regulates the employment law is the EOC, or Equal Employment Opportunity Commission. It is required for a prima facie case of sexual harassment. To make out such a prima facie case of hostile environment sexual harassment, a plaintiff must show that she is a member of a protected class, she is the subject of unwelcome sexual harassment, and the harassment occurred because of her sex, and the harassment was sufficiently severe or pervasive to alter the terms and conditions of her employment. What are the requirements for a religious discrimination claim under Title VII as discussed in the Webb versus City of Philadelphia case? So Title VII prohibits employers from discharging or disciplining an employee based on his or her religion. Religion is defined as all aspects of religious observance and practice as well as beliefs. And to establish a prima facie case of religious discrimination, the employee must show that she holds a sincere religious belief that conflicts with a job requirement, and it can be he. She or he informs her employer of the conflict, and she or he was disciplined for failure to comply with the conflicting requirement. Once all factors are established, the burden then shifts to the employer to show either it made a good faith effort to reasonably accommodate the religious belief, or such an accommodation would cause an undue hardship upon the employer and its business. What is a disparate impact claim? In Griggs versus Duke Power, the Supreme Court held that Title VII prescribes not only overt discrimination, but also practices that are fair in form but discriminatory in operation. These kinds of claims are known as disparate impact and involve employment practices that are facially neutral in their treatment of different groups, but that in fact fall more harshly on one group than another and cannot be justified by business necessity. What is the Pregnancy Discrimination Act of 1978? In 1978, Congress made it clear that discrimination on the basis of pregnancy was illegal, and this is what the Act protects against: pregnancy discrimination. What about the Family Medical Leave Act of 1993? This act provides that an eligible employee shall be entitled to a total of 12 work weeks of leave during a 12-month period for one or more of the following: because of the birth of a son or daughter of the employee and in order to care for such child, because of the placement of a son or daughter with the employee for adoption or foster care, or in order to care for the spouse, son, daughter, or parent of the employee if such spouse, son, daughter, or parent has a serious health condition, because of a serious health condition that makes the employee unable to perform the functions of the position of such employee, because of an existing or qualifying exigency arising out of the fact that the spouse or a son, daughter, or employee or parent is deployed overseas or notified of an impending call to be deployed overseas in the armed force. And this law guarantees that an employee who returns from a leave can go back to his or her position or one with equivalent benefits, pay, and conditions without losing any benefits that have accrued prior to the leave, although without gaining any seniority while they are on leave. In 1990, Congress adopted the Americans with Disabilities Act. This law makes it illegal for employers to discriminate against a qualified person on the basis of disability and requires the firms to make reasonable accommodations so that the disabled are given more opportunity to enter the mainstream. The concept of reasonable accommodations is broad and flexible, requiring that requiring not only physical changes but also adjustments in the way that people work. Examples could include flexible work schedule or modified job descriptions. It is not, however, intended to impose an undue workship on the business. The law requires courts to construe the definition of disability broadly, clarifying that a person meets the definition of disabled if he or she has an impairment that substantially limits even one major life activity, and even if the disability is episodic or in remission. What is the Equal Protection Act? This is a clause in the Constitution that rests on the central notion that government must be fair and reasonable and not arbitrary. It can sometimes treat classes of people differently, but only if the classification rests upon differences that has a fair and substantial relation to the goal or purpose of the law, so that all persons in similar circumstances under the Equal Protection Clause must be treated alike. Chapter 6 talks about health and safety, workers' rights as humans. Occupational Health and Safety Act and what tools are available to enforce this act. With the adoption of the Occupational Safety Act in 1970, the United States began to address the need to prevent or minimize workplace accidents and health hazards. This act established a general duty on the part of every covered employer to maintain a work environment free from recognized hazards, causing or likely to cause death or serious physical harm to employees. It also created a federal agency, which is called OSHA, which is empowered to oversee safety and health standards by enforcing the General Duties Clause and by writing and enforcing detailed health and safety standards for each industry. With limited resources, OSHA achieved its mission through a balanced approach consisting of standards, enforcement, compliance, assistance and outreach, and whistleblower protection. OSHA's targeted severe violator enforcement program includes increased OSHA inspections of certain employers, mandatory follow-up inspections, and inspections of other work sites managed by the same employers. What is the workers' compensation claim? Firms contribute to a workers' compensation fund that is used to pay benefits to employees accidentally injured in the workplace. Instead of suing, an injured employee need only file a claim indicating that he or she was hurt in the course of his or her employment. He or she need not prove that the company was negligent, nor can the company raise any of the traditional defenses to negligence to defeat his or her claim. Employers are willing to accept this approach because there is a trade-off. If workers' compensation covers an injury, the employee cannot sue for negligence. The employer will not face the risk that a jury will hear the case and award large damages. This is the exclusivity rule, so called because the employee's only or exclusive remedy lies with the workers' compensation claim. Payments are set by a formula and generally provide less than the actual wages lost, and no provision is made for the kind of award that would result in high numbers or like punitive damages. What is the Workers' Rights Consortium? This consortium combats sweatshops by monitoring and investigating working conditions in factories around the world. And as of June 2016, some 186 colleges and universities across the United States had joined this consortium. Licensees agreed that they and their contractors would adhere to the laws and local country or standards set forth in the code of conduct that has been adopted by this group. Chapter 7 deals with environmental sustainability, law, and fairness. What is the Comprehensive Environmental Response, Compensation, and Liability Act? It is a liability scheme rather than a monitoring program. It created a $1.6 billion fund or super fund to help finance the cleanup of toxic waste sites when the polluters would not or could not pay. Up until 1995, the super fund received its funding from taxes on oil, chemical, and certain other kinds of companies. Since the Superfund taxes expired in 1995, the government has had to look to general revenues to pay for such cleanup. Potentially responsible parties include owners or operators of hazardous waste sites, those who owned or operated the sites when the hazardous material was deposited, the generators, or those who create the waste, and the transporters, those who carry it to the sites. What is the cap and trade, also known as emission trading? This governmental regulatory program determines the limits or sets the caps for the maximum level of emissions of specific chemicals during a private business activity. It's a tradable permit system. It was authorized by the 1990 amendments to the Clean Air Act. The EPA issued to power plants a set number of permits of sulfur dioxide emissions each year. Firms that could install pollution controls had the incentive to do so and could sell their surplus permits. Firms that chose not to control emissions could use up their permits and buy more. Cap and trade offers flexibility for industry and can reduce overall emissions at a lower overall cost. But these very efficiencies can create harmful consequences. In neighborhoods with a concentration of older plants, the permit system provides an incentive to continue dirty operations by allowing companies to buy the right to pollute instead of investing in cleaner technologies. Communities living near these outdated plants would become emissions or hotspots, endangering human health. Kyoto Protocol. Through the 1990s, as nearly 200 countries reached agreement on the Kyoto Protocol, the world's first treaty to reduce greenhouse gas emissions, the United States declined to join. The Kyoto Framework committed ratifying nations in the developed world to phased in emission reductions with restrictions on developing countries to follow. What is the Federal Insecticide, Fungicide, and Rodenticide Act? This act is known as FIFRA. It prohibits companies from selling any pesticide that the EPA has not approved and registered. Specifically, the act allows the EPA to deny an application for registration of a pesticide to prevent unreasonable adverse effects, defined as any unreasonable risk to man or the environment, taking into account the economic, social, and environmental costs and benefits of the use of the pesticide. In order to register a new pesticide, a manufacturer must submit an application for registration describing how the pesticide will be used. According to John Locke, what gives a person the right to own property? Are there any limitations, and why does Locke believe people form government? Locke discussed in Chapter 7 sweat equity, and he stated by adding his own labor to the raw stuff of nature, a person creates his own right to own that part of nature as long as there is enough left for everyone else to do the same. According to Locke, the purpose of government is to preserve individual freedom. In this role, government should keep people from interfering with others' enjoyment of their private property. This reflects the influence of Hobbes on Locke. According to Thomas Hobbes, the original state of nature was a time of war, of all against all, when life was solitary, nasty, brutish, and short. As a matter of survival, people agreed to submit to a sovereign with the power to enforce law. In the excerpt titled On Care for Our Common Home, what are Pope Francis's views about the environmental protection? Pope Francis focuses on the government's duty to protect the common good by protecting the planet. He indicates that overconsumption of natural resources should be avoided, as should actions that unduly burden others' rights to enjoy their property. Pope Francis places the earth in a position of respect and calls for actions that are geared towards preserving nature. Pope Francis grounds his respect for the earth in a social context because it provides resources for people, and in a spiritual context, it was created by God and therefore should be treated with respect. He stated that climate change is a global problem with serious implications: environmental, social, economic, political, and for the distribution of goods. It represents one of the principal challenges facing humanity in our day. Also, he stated, along with the importance of little everyday gestures, social love moves us to devise larger strategies to halt environmental degradation and to encourage a culture of care which permeates all of society. What is eminent domain? The Fifth Amendment to the U.S. Constitution states that private property may not be taken for public use without just compensation. The power to take private property for public use is called eminent domain. It may be exercised by local as well as federal and state government. Historically, it has enabled public projects such as the construction of highways, utility lines, parks, and rapid transit systems to move forward in spite of private property interests that might otherwise have blocked these projects. Chapter 8 deals with marketing, technology, choice, and manipulation. What are the two assumptions of consumer demand theory that Galbraith explains in the excerpt titled The Dependence Effect? These are: the urgency of wants does not diminish as more of them are satisfied, and wants originate in the personality of the consumer. What is free speech? In Central Hudson Electric Corp versus Public Service Commission, the court set out a four-pronged test. First, commercial speech will not be constitutionally protected if it's misleading or concerns illegal activity. Speech that qualifies as protected commercial speech can still be regulated. However, if three conditions are met. First, the government must demonstrate a substantial interest in regulating the speech. Next, the regulation must serve its purpose and must directly advance whatever government interest has been asserted. Finally, the regulation must be tailored to fit its purpose and be no more extensive than necessary. In First National Bank versus Bellotti, a Massachusetts bank wanted to publicize its opposition to proposed legislation for a graduated income tax. State law made it a crime for a corporation to advertise to influence voters on issues that did not materially affect its business, adding that no law regarding taxation would materially affect a corporation. For the first time, the Supreme Court recognized that not only individuals, but corporations, also including banks, have First Amendment rights. It went on to hold that Massachusetts law infringed upon the bank's First Amendment rights. Freedom of speech is guaranteed by the First Amendment to the U.S. Constitution. Today, unless it is deemed defamatory, obscene, or likely to incite violence, expression, including artistic and symbolic expression, is protected in what has been dubbed as the marketplace of ideas. By 1980, the Supreme Court had established a rule for challenges to governmental regulation of commercial speech. What is native advertising, sometimes called stealth advertising? It's so smoothly embedded in its surrounding content that it's hard to tell that it's advertising at all. In the late 2015, the FTC, or Federal Trade Commission, released a policy statement identifying three forms of native advertising that could be deceptive under this act: advertisement in a newspaper format or that misrepresents its source, misleading door openers, and deceptive endorsements. What is the Lanham Act? While the focus of this act is trademark registration and protection, Section 43 gives competitors the right to sue for false or misleading advertising damaging to them. It has been interpreted to allow suits for false claims about either a company's own products or those of its rivals, and to include not only traditional advertising campaigns, but also infomercials, labels, and messages on telephone answering machines. To succeed under the Lanham Act, a plaintiff must prove that the defendant made a factual misrepresentation about a product or service, something more than sales puffery. What is the creative revolution in advertising? It's often dubbed as a creative revolution. Advertisers turn instead to more symbolically and culturally driven messages, building brand value on the basis of popularly held cultural traits. They stress brand images with campaigns designed to convince consumers that Nike equals power and athleticism, or Pepsi is the brand of the youth rebellion, for example. As Thomas Frank has argued, the core of the creative revolution was an appeal to nonconformity and the countercultural quality of cool. The association of a brand with coolness becomes a common strategy in adult and teen marketing. What is the learned intermediary doctrine discussed in Perez versus Wyeth case, and what were the reasons given by the majority for not applying this doctrine to the direct to consumer advertising of prescription drugs? Traditionally, companies had a legal duty to warn consumers directly of dangers associated with their product. An exception called the learned intermediary doctrine developed, however, in the area of pharmaceutical drugs. Manufacturers do not have to warn consumers as long as they have warned physicians adequately. The reasons given by the court of not applying this doctrine for the direct-to-consumer advertising of prescription drugs include: managed care has reduced the time allotted per patient. Physicians have considerably less time to inform patients of the risks and benefits of a drug, and drug manufacturers can hardly be said to lack effective means to communicate directly with patients, when their advertising campaigns can pay off in close to billions. As a result, manufacturers need to include warnings in direct-to-consumer advertising.